entering international treaties.
Thank you, Senator McEwen. Senator Siewert.
Thank you, Mr Acting Deputy President. I rise to contribute to this debate and talk about this bill, a very sensible bill that Senator Whish-Wilson has introduced as a private member's bill. The purpose of the bill is to prevent the Commonwealth from entering into an agreement with one or more foreign countries that includes interstate dispute settlement provisions. The concern that I've just heard expressed by the Labor Party, I think in part seeks to muddy the waters by saying it restricts the ability of governments to enter into treaties. We have had legal advice. Senator Whish-Wilson, I said, has legal advice that, in fact, to suggest that it doesn't, but he's also indicated on occasion that if there is some issues with some wording of it, to make it clear, we could consider amendments. It's interesting too that despite speaking strongly about the issues around interstate dispute settlement provisions, the Senator McEwen for the Labor Party didn't mention that they've just supported, or didn't seem to think that it was important, that in fact the Labor Party has just supported and voted with the government on the CAFCA agreement, which sets a bad precedence for negotiations on the TPP. If they so strongly believe that these issues were of concern, they should have voted against it, in fact, and forced a renegotiation, because, as I said, it does indicate bad precedents for the TPP, which does include US corporations who are very litigious, and I'll come back to that issue now. We should be sending a message now that these forms of provisions, these form of provisions are not acceptable now. They may have been useful in the past, but the world has significantly changed and our legislation needs to move on so that we ensure that investor-state dispute settlement provisions don't give foreign corporations excessive powers in this country. Free trade agreements are no longer simply concerned with the exchange of goods and services. The inclusion of foreign investment ensures a much more complex system which doesn't necessarily make for a better one. The Greens are very concerned about the government's proposals to include investor-state dispute settlement provisions in future free trade agreements, which could allow foreign companies to sue the government if they consider their business interests to be impinged on by policy or legislation decisions of the government. This is big business being insinuating itself into the decision-makings of a state. It is crony capitalism at its extreme. The Australian Greens Trade and Foreign Investment Bill seeks to ban the inclusion of investor-state dispute settlement provisions in future trade agreements in order to protect the public interest. Sovereign risk is part of the consideration for companies who want to invest in foreign countries. Risk is a part of doing business. Investor-state dispute settlements, or ISDS provisions, allow foreign corporations to sue governments if they feel regulations and policies impact on profits. They give corporations a lot of power, and there is no proof it increases investment flows. No right of appeal in the arbitration process, and has very little transparency. And there's very little transparency of what goes on. Labor refused to sign up to ISDS when they were in government, but they still voted through, as I've just said, the Korean-Australian deal, which had ISDS in it because they and we think they didn't want to be seen to be blocking trade deals when this has significant implications for decision-making in this country. The government won't acknowledge or don't understand the risks because what they want is to get the trade deals done. However, I must note that Mr Howard refused to allow ISDS clauses in the Australian-US FTA. If we get ISDS in the Trans-Pacific Partnership Agreement, US companies will have the right to sue the Australian government. US corporations are the biggest users of ISDSs, and we expect cases against the government would increase if we sign the TPP. ISDS applies to state and local governments as well, has significant implications across Australia. We oppose ISDS provisions for a number of important reasons. Litigation using ISDS has proliferated in recent times, and this is likely to increase into the future. You can expect that it will. If you put it in the agreement, you can expect that corporations, particularly US corporations, will use it. ISDS clauses have outlived their usefulness and are now under review in a number of countries and in a number of trade negotiations, including 10 countries in Latin America, South Africa, India, Indonesia and the European Union. After decades of public debate, it's time to rethink their inclusion in modern trade agreements because circumstances have significantly changed from the times that Senator McEwen was talking about. It's no longer used for those purposes. The purposes that these provisions are used for is to allow multinational corporations to take control, essentially, of key policy decisions or oppose policy decisions that countries make. It is unacceptable. There is no evidence that ISDS clauses have any economic benefits for trade or investment. However, the risks of using them are clear and supported by evidence and numerous case studies, a couple of which I'll go into shortly. Trade deals are changing from historic market access trade driven considerations to facilitating and protecting foreign investment through limits placed on the ability of the government to develop domestic laws and policies in a wide range of areas, including public health, patents on medicine, the environment, food labelling, internet use and privacy, and local media content. This makes the inclusion of ISDS provisions more dangerous. Although current ISDS litigation by the Philip Morris Tobacco Company against Australia's packaging legislation is globally significant, we have only escaped the danger of more cases because previous Labor and Liberal governments have only included ISDS in trade agreements with developing countries which do not have investments in Australia and haven't included them in the US-Australia Free Trade Agreement. US corporations are the most frequent users of ISDS. The current Trans-Pacific Partnership Agreement, the TPP, has proposals for ISDS in ongoing negotiations, which would therefore expose Australia to a much higher risk of litigation. There was strong evidence presented to the inquiry that ISDS safeguard clauses can and have been reinterpreted and overturned through the arbitration process. Australia has no oversight or control over the inclusion of ISDS in trade negotiations or other aspects of for that matter, of the secretive trade talks. So legislation is the simplest way to remove the risk of their use into the future. The Australian Greens Trade and Foreign Investment Bill, as I said, seeks to ban the inclusion of ISDS in future trade agreements in order to protect the public interest. Why should we be beholden to foreign investors' vested interest to the detriment of our own citizens? Because that's the very, very real risk. I'm particularly concerned around the impact of ISDS provisions on Australian agriculture and the health and well-being of Australians. I urge farmers to take a stronger interest in the inclusion of these provisions because I think it'll lead to adverse impacts on farmers in this country. I urge them and their representative organisations to pay attention to these provisions. The inclusion of ISDS provisions inclusion of ISDS provisions are a potentially detrimental policy for Australian agriculture. There are already examples of Monsanto suing foreign governments for decisions they see as not being in Monsanto's best interests. We like to have a look at the example of Monsanto and Guatemala. In a landmark decision on September 4, following intense pressure by Indigenous people, trade unions, farmers' organisations and others, the Guatemalan judiciary ruled to suspend the controversial plant variety protection law, commonly referred to as Monsanto law, because of the multinational biotech companies' involvement in it. If passed, the Monsanto law would have been given exclusivity on patented seeds to that law would have given exclusivity on patent seeds to transnational companies. But opponents claim that the new law violated the Guatemalan constitution and the people's rights to traditional cultivation of their land in their ancestral territories. The law offers producers of transgenic seeds, often corporate companies like Monsanto, strict property rights in the event of possession or exchange of original or harvested seeds of protected varieties without the breeder's authorisation. A breeder's rights extend to varieties essentially derived from the protected variety. Thus, a hybrid of a protected or unprotected seed belongs to the protected seeds producers. And what are the implications of this? Well, for one, if a Guatemalan farmer who had been tending his or her land for generations violates the law, wittingly or unwittingly, he or she could face a prison term of 1 to 4 years and fines of US $130 to $1,300, which is very hefty for farmers in that country who are frequently living on the brink of poverty. That the new legislation would have opened up the market for genetically modified seeds, which would have threatened or displaced natural seeds and end their diversity. This is an extremely dangerous proposition because it threatens food security by introducing a vicious cycle to Guatemalan farmers. With the introduction of modified seeds, it would be hard, if not impossible, to revert back to using indigenous seeds, making Guatemalan farmers dependent upon the foreign seeds. Expensive, I might add, foreign seeds. And by law, once genetically modified seeds are invariably mixed with the natural seeds, the end result would be legally owned by the property rights holder, i.e., guess what, Monsanto. In a publication, the Rural Studies Collective warned about the consequences of this Monsanto's law, describing how the law promotes privatisation and monopolies over seeds, endangering food sovereignty, especially that of Indigenous peoples, and that Guatemala's biodiversity will fall under the control of domestic and foreign companies. That's right, handing over that biodiversity to companies to own. If passed, opponents claim that Monsanto's law could have made criminals of already repressed small farmers who are just trying to cultivate crops for their own consumption, which they have been doing for generations. The law would have prevented Guatemalans from growing and harvesting anything that originates from natural seeds, and farmers could be breaking the law if their seeds had been mixed with patented seeds from other crops as a result of pollination or wind, unless they had a licence for the patent seed from a transnational corporation like Monsanto. In a statement issued in July, the National Alliance for Biodiversity Protection explained, according to this law, the rights of plant breeders are superior to the rights of people to freely use seeds. It's a direct attack on the traditional knowledge, biodiversity, life, culture, rural economy and world view of peoples and food sovereignty. I'm glad somebody agrees that that's what Monsanto's law would have had resulted in and understand that issue. Beyond the domestic repercussions of this ruling, it could also affect Guatemalans' membership in the Central American Free Trade Agreement. The Free Trade Agreement between the United States and a group of smaller developing countries includes Guatemala. The Plant Variety Protection Law originated back in 2004 when Guatemala joined the agreement. And agreeing to Monsanto's law is part of the agreement's requirements. Should Guatemala or another nation have to listen to the demands of the US by honouring their free trade agreement laws? Not according to the Natural Society. Big ag, and I quote, big ag and big biotech would severely threaten international food sovereignty. More than 40 countries have already realised this possibility, banning GMO crops. There are reports that Monsanto intends on suing the Guatemalan government under the ISD provisions following this decision. We don't want this to be happening in Australia. You only have to look at the cases in Australia where look at what could happen in Australia, where we have farmers that wish to grow organic crops. We have farmers that wish to not grow genetically modified organisms. This law could threaten our ability to make laws to protect farmers from GMO crops, and the Steve Marsh case in Western Australia is a very good example. You can easily foresee a situation where Monsanto brings a case against Australia if we did bring in laws that protected farmers such as Steve Marsh from contamination, or gave them, put in place strict liability laws, for example, put in place labelling laws around genetically modified organisms so that people knew what food they were eating and knew if they were eating genetically modified organisms, so that they know that they're eating organic food because they have made a choice. So not only will this law, could these provisions, ISDS provisions, enable US corporations to bring actions against Australia, not only for some of the other circumstances, an impact on growers, but also consumers who wish to make decisions about what they eat. This potentially could extend to taking that control away. I'd like to quickly just look at food security in the southwest of WA. In the southwest of WA, we are being significantly impacted by the impacts of climate change already. People are having to make choices about what they wish to grow, and they're looking at those markets that are clean and green. They're looking at the markets that don't want to be consuming genetically modified organisms. They want to capitalise on those markets, so they are starting to make decisions about what they grow and in what circumstances. Again, these particular provisions could be significantly impacting on their choices about what they grow. ISD provisions could also limit farmers' rights in regards to stopping fracking on their land. There are disputes, for example, there are disputes against Canada in Canada. Investors are challenging measures that were introduced on environmental grounds. One, a claim by Lone Pine Resources, arose out of Quebec's moratorium on fracking, hydraulic fracturing or fracking, that led to the revocation of the company's gas exploration permits. The ISDS litigation concerning mining has steadily increased over the past decade. Oceana Gold, an Australian company, currently has a subsidiary that is suing the El Salvadorian government through the ISDS for more than $300 million. Almost half the government's annual budget over the government's refusal to grant a gold mining permit. Do we want that happening in this country? This bill should be passed. It should be passed to protect the interests of Australians and Australians, and to protect the interests of farmers and the community in ensuring they have their own ability, and we have our own ability in Australia, to making decisions that are in this country's, our people's, our farmers, our consumers' best interests. Going down the path of supporting, in this modern age, the ISDS provisions facilitates global companies, multinational companies, taking over the decision-making of a country. If they can bring litigation against environmental standards, against provisions that protect our food sovereignty, our decision-making, where we choose to mine, we are handing over decision-making to unelected, transnational, multinational companies. We don't believe Australians want that. We believe they want those decisions to remain with Australia. We think this is the sensible road to take, and we urge the Senate to pass this legislation.